All right, so Sex in a Box Part 2.
Sex in a box.
Part 2.
I know. So what do we mean by sex in a box?
So we spoke about this a little while ago on a podcast. We called it Sex in a Box, but this was about a case that we just got judgment on yesterday where the client was found not guilty. But it was a retrial where there was an allegation of sexual assault at the beginning of a person's relationship. And then the accused and the complainant carried on a relationship for about a year and a half. And at the breakup, for other reasons, the complainant decided to go to the police. During the course of that discussion with police, she made these allegations of this sex assault that happened a year and a half before.
So we're talking about basically other bad character evidence that if you expand the box outside of the time frame of the allegation, then you open yourself up to bad character evidence. And what do we know our clients think?
So it's psychologically is very interesting. Go ahead, say it.
They come in saying, I've got a ton of people who say I'm a nice guy.
Well, that's true.
Good character evidence.
Yeah, and you can call character evidence, but it has virtually no impact whatsoever.
Most of our clients think that they come in and say, I've got like 10 guys who'll say I'm the best person they've ever met.
Yeah.
So why is that not important?
Well, in a regular person's mind, they might feel that I'm not the type of person who would do something and invade somebody's integrity or go against their boundaries, and so they think, unlike lawyers, that that may have some relevance to a judge. And you know what? It's interesting because I've said in jury closings, what do you really know about these people? What do you really know about the complainant? Yet a judge and a jury is making a decision that's life-altering based upon a fragment of a person's life, a fragment of knowledge of who they are, and knowing very little about who they are, essentially emotionally and psychologically. So I understand why the impetus is for people to say, a court should know who I am, and calling people who know me, who would say positive things about me, would give the judge a better, context in which to make a decision. But it's not admissible.
You've made a point before, too. It's like one of the last things you want to do is put your character on trial.
Correct. And so this was interesting because in a lot of our cases, we may have a good, healthy amount of evidence that we can rely on to attack the credibility of the complainant. And that will go to a number of issues, including the complainant's conduct in relation to our client. So, we've had the reverse of this coercive control, and we've been able to establish that, in fact, a complainant is the one who has been very controlling and manipulative and lying and doing all sorts of things, which was very important for our defense. And psychologically, in this case, and in others, some lawyers and some clients want to go scorched earth. I have all these messages. I can counteract everything she says about this in bad character, and this is the way we're going to prove that she's lying and I'm telling the truth.
No, I came up with this phrase, sex in a box, a while ago, before I actually met you. And
this is from you, yeah.
I had a really funny video where I did a little sex in a box with Smurfs and Gargamel.
Yeah.
So the thing that's interesting is this crossed my mind when the big fiasco happened about Justice Camp, former Justice Camp, Robin Camp. He was the keep your knees together judge or whatever.
Right.
There was a situation in that case in which they had a witness that said the reason these two people ended up in the bathroom together alone was because I was in there and I said, are you going to f***? And she just goes, yeah. And so I go, all right, I'm out. And the complainant version of event was, I was in the bathroom throwing up and he snuck in like a ninja. And meanwhile, they have a witness who's saying that we were in there smoking pot together. And the prosecutor argued that this witness should not be allowed to testify because the moment she closed the door, she doesn't know what happened. That was sex in a box.
Mm-hmm.
No, the reason they were in the box is actually relevant.
So that's the origin of your term about it. And I think sometimes, though, rather than expanding it's important to...
No, but this is so interesting. Why we were like going, we shouldn't. Your shoes are really nice.
Thank you. Thank you.
Sorry.
He's looking good today.
I know.
Thank you, guys.
But the reason, like, originally I was afraid of this sex in a box thing, but then we found a reason why to put it back in the box, and that's where we're going to go.
Yeah, you always have to do this cost-benefit analysis.
Great shoes.
Thank you. Is that, the instinct to try and attack everything the complainant says is not always helpful. And you have to do this analysis to determine, am I going to elicit far more prejudicial information from the complainant than really is necessary? And I think it's important now that we have the judgment and can actually say it was the right call, because we excluded, a year and a half worth of evidence
everything.
that I think would have just created noise and would have actually maybe gone against our client's benefit and could easily result in a conviction by letting in all sorts of extraneous information that would then, he would have to then battle on cross-examination. I mean, it's just, and we've done this now in 2 or 3 cases that we're setting up for trial, where we've said, no, we're not getting into these areas, because I think in what's really important is, again, calling our client to testify is extremely important. But then you got to realize they not only have to battle the allegation. In so many cases, it's like you're battling 30 different allegations. He was late for dinner. He didn't give me a card on our anniversary. He didn't I'm being facetious, but there's all these things, and it becomes...
He insulted me for not saying thank you when somebody opened the door for me.
That's right. Literally, and the
that was actually an allegation.
seeping in all this bad character evidence detracts from what we have as real evidence to deal with, and then it becomes very difficult for a client to navigate when testifying, and particularly difficult to navigate when being cross-examined and falling into various avenues of winding up looking like they're lying. And that's the danger, and that's why I think we have to be super important or super careful about determining what's important and what isn't.
So here's the thing, though, is like clients will come in and they'll be like, oh, I've got emails where she said you were late for dinner or something like that. It was like, I'm sorry, how is that useful? But and then they question, why are you using this? Well, you have to really think about what's useful and what's important and what relates to the allegations. Or are you just going to put yourself on trial for your character?
Yeah, so let's use another example of sex in a box. So it, just to close the loop on this one, it had the desired effect because it focused the evidence, it focused examination of our client, it focused cross-examination, didn't open him up to other areas that could have potentially been dangerous and could have led him down a path where he could have got convicted. So that was a good thing. In another case, yes, you're right, and we do ask clients, give us everything you have. Give us all your messages. Give it everything. We'll look at it and decide what's relevant. And it is a natural instinct to say, well, I can show that she's not telling the truth about this. She's not telling the truth about that. She's not telling. But a lot of it is irrelevant.
What do we find? The stuff that turns out to be relevant are things that the client didn't even recognize.
Right, and that's where we come in, because we're the lens through which we're going to do the storytelling, and we know what's relevant. And you talk about that because
you focus on what the accusation is, right? So you have to focus on what you're accused of and what's relevant to the accusation. And the weird thing I find is that these clients, they're so immersed in their own experience of what happened to them, they can't see the bigger picture.
But yeah,
it takes somebody outside of the situation.
Yeah, but I think from our perspective as forging the defense and sort of analyzing the case, it's very important to ensure that each piece of evidence that the client will give you is reviewed in the context of what the Crown's evidence is and in the context of you building your own narrative. Yeah. And then making that determination. I've said this before, that we're working on our cross-examination almost at the beginning, at the same time that we're drafting up an application to admit evidence, but we're doing it all at the start to try and have this one coherent path. And you have to assess everything very carefully and only go with what is relevant and what's going to give you a big bang.
And it's so important for clients to participate in their own defense, right? To give us a chronology and their, to explain their story and stuff like that. But at the same time, it's so important to have a third perspective on it, because you get, like I said, sucked into your own case, and and the things that stand out to them aren't necessarily things that are going to be important at their trial. And here's the other thing: why should people not represent themselves?
Yeah, well, yeah. I mean, oh yeah. But I mean, we've had interesting meetings where I guess for lawyers who are watching this, that maybe they do it as well, and they can let us know what their perspective is. But after 2 or 3 meetings with a client where we're discussing their evidence in the case, there are those that sort of transcend the accused per se and are able to participate in understanding the evidence and the flow and how the defense is being built and how we're attacking the reliability and credibility of the complainant, which makes them a far better witness at trial. They just start to become more immersed in understanding the process and getting the logic behind everything and understanding their defense, which may seem pretty basic, but then it makes them a much better witness.
Yeah.
And we've had that experience, which has been pretty damn good. But you got to be really careful about assessing letting them talk, but trying to get them down that right path, but not letting them control the defense, because then you can go down so many routes that are just awful.
Well, and that's the problem, and this is why we want to put things back in the box, right? Because, you can ask somebody something and get them to wax poetic about all of their kvetching. It's one of my favorite Jewish words.
Yeah.
Kvetching about everything, right? Has nothing to do with your trial. Don't even go there. Just keep it in a box.
Right. Well, I understand that. Again, we're dealing with people
going back to the subject.
No, I know, but I mean, we're dealing with people who are, when our clients come in, they're pretty traumatized. We've dealt with people who are extremely emotional. They're going through depression. They're going through anxiety. It's really bad. Our clients often wind up having to get, we refer them out for help because it's an awful situation. But this sex in a box is super important, because particularly if you're dealing with an allegation in the context of a relationship, you've got to be really careful about identifying what your motive to fabricate is, identifying where you want to go in cross-examination, and then identifying what's relevant, what's going to help you in your cross-examination, as opposed to eliciting a ton of other evidence that will not be helpful. And I think, and then also other sexual activity, and other sexual activity sometimes is really helpful. But honestly, not all the time, No,
because you can't say because she had sex with me on this other day. Obviously, she had sex with me on the day of the allegation because she did it before and she did it after.
Right. So we can't get into twin myth reasoning. It's completely irrelevant.
I know.
But even though you may find,
even though this is common parlance for us and for lawyers who might be watching,
yeah.
Twin myth reasoning means you cannot argue that somebody is more likely to have consented or less worthy of belief simply because they had sex with you on another occasion.
And I think what I was driving at is that even though you may have some aspects of other sexual activity that could be relevant, that we could ground in the evidence of the complainant and make specific arguments as to why it's admissible, sometimes, it's not worth it, because you'll go down another path that can still get you into trouble. It's so much like a chess game, where you're plotting out your moves ahead of time, that you and I, it's just been an interesting transition. I think this is why we wanted to come back to sex in a box, because at the beginning, when Bill C-51 came in, we were very used to, that's when, again, this whole new regime came in about vetting documents in your possession, everything. You
have to lay your whole defense out in advance.
We were always very careful about determining what's relevant in line with our cross-examination.
You want to hold your cards close, mostly, right?
Well, you never gave it away before. We never had to give defense disclosure.
Now you have to.
But we were in the, at that point, I'd been practicing, 26 years, 27 years. So, well along the way of always having the same approach. What? That long? Why?
You're dating yourself.
Who cares? But anyways, but what I'm trying to say is that, we've always had the approach. But then once that legislation came in, it had this big sort of psychological impact, thinking, we're going to have to disclose everything, and we want to get in everything because we want to be able to, like, there was just this desire to get everything you wanted in, and now several years later we're coming back around to it going, you know what,
Have at her.
it helps us screen a little bit more, I think. Although we had the instinct to want to get everything in because that legislation happened, it should not have changed the way of thinking that, again, you still have to be very selective about everything. And so we've come sort of full circle in being relaxed about the legislation because 99% of the time we're going to get in what we want because we ground it properly. But, it's sometimes focusing and putting it in a box and keeping it more simple is much better for having a judge focus and much better for our clients when testifying.
Yeah.
Now, you want to say something else?
Have at her.
Okay, so let's just talk about one other thing in this one. Trauma-informed approach to how a person remembers.
We came across this in the decision that we just received. It's the first time that phrase was used, and I find it so...
It was the first time in any of her cases I've heard a judge refer to that in a judgment.
I find it so upsetting because trauma-informed approach is actually reverse science.
Okay.
It is where they look at the reasons why somebody would not be believed normally. They would fail the test of beyond a reasonable doubt, and they reverse scienced it to say, oh, no, all of these things, inconsistencies, lack of memory, all of these things that would normally undermine the ability to reach a conviction, they said, oh, this is all proof of rape.
Yeah, and I think the judge, so it's interesting. So again, you will hear a lot and have heard about people testifying about how trauma affects how somebody will perceive events and then be able to remember them and give detail at a trial. And therefore, lack of detail or lack of specifics or inconsistencies is not signs that somebody should not be believed. And they try and package it. And in this particular case...
Repackage it to make it look like proof of rape.
And so in this case, it was argued that it's natural that the complainant would not remember some very significant things because of the trauma of the event. And so this was the first time we've had a judge refer to it. I don't think in the end it made a difference because I think it was lip service because what you still have to look at, and there's plenty of appeal decisions on this, is that lack of detail can be taken into consideration when assessing reliability and credibility. It doesn't mean you should just outright... it's just in the newsletter.
You follow our newsletter.
Yeah.
We've got a case coming out about this, yeah.
But,
it's not a rape myth to say a lack of detail is, insufficient to convict somebody. That's not a rape myth. It's actually just an issue with the evidence at trial.
It's just an issue that goes to reliability.
Yeah.
And lack of detail sometimes it's significant, sometimes it isn't. Sometimes an inconsistency is material, sometimes it isn't. It just goes all into the soup at which you assess a case.
Right? I'm going crazy. Because what do we know about trauma? When something traumatic happens to you, your memories are vivid.
Sometimes, not always.
Slow motion, vivid.
I think everybody reacts to a bad experience in a different way.
People can be different.
Yeah.
But the majority of research says that when something traumatic happens to you, it happens in slow motion. You remember everything. And yet we're being told that when something traumatic happens to you, you remember nothing.
I don't think they're saying you remember nothing, but I think what they say...
Where's the science? There's no science.
Well, that's why we had, in a previous episode, I just think we should take the science out of it. I mean, I think from a common sense human nature standpoint, we understand that people will experience things differently. But when you're assessing a case beyond a reasonable doubt, as was argued in this case by the Crown, all this lack of detail, all this lack of
Martian.
details with respect to the mechanism of how this actually happened was to the complainant's favor and therefore should be believed. That's just bullshit. And that's what you have to be really careful about. You know why I love law?
Because I'm about logic. Right?
Yeah, but it's not always logic, right?
I love the idea that you can take one case and it has nothing to do with another case, but the logic applies the same across the board, right? Apparently logic has gone out the window.
I don't know.
When it comes to trauma, and apparently...
I think the courts are still pretty cautious about it. We'll see what the comments are, but I think the courts are pretty cautious about it. We haven't we haven't faced this too often where I think it's being pushed too hard. And I think judges understand what the appellate courts instruct and give guidance on.
Is it science?
No, it's not science.
That's the question. Is it science?
Well, it's like, again, I mean, I don't want to repeat myself because there's another episode we talk about this, but there's a whole industry built around criminal law, right? To make people relevant, to get money into stuff,
That was funny.
to try and push.
I feel relevant.
No, but it to push agendas. You know, there are these industries that are built up, and they want to still exist and make money. So I think that's, really problematic. Anyways. Problematic. All right. I'm exhausted. We need a vacation.
I know.
Take care, everybody. Please, if you like our podcast,
just pray I don't get eaten by a shark.
don't go swimming off the shore of Florida. Don't forget to. Where's our pillow?
Oh,
don't forget
you get it this time.
Yeah. Don't forget to what?
Like, comment, subscribe, share.
And keep those comments coming to us. Thank you very much. Have a good summer.